Good morning, everyone. This is Dorsey's interactive dialogue presentation. Today's topic is on the changing landscape of AIA proceedings. So today's presentation will be mainly by Clint Connor, whose practice focuses on intellectual property with a focus on patent litigation, IPRs, and enforcement strategies. Clint is a partner in our Minneapolis headquarters and recently led a team here at Dorsey to a walk-away defensive victory in an 11-patent suit where IPRs played a major role in the win. My name is Gina Cornelio, and I'm a partner in the Denver office of Dorsey and Whitney, and I mainly focus on patent prosecution. The way these interactive dialogues are meant to be is to include to really be more discussion-oriented. So feel free to go ahead and type in questions as we're going through the slides in the Q&A box on your screen. We'll try to address those as we go to help keep this conversational. And there will be some time for questions at the end as well. But like I said, we are more than happy to kind of address them on the fly. And now I'll turn it over to Clint to get started.
Well, good morning, everybody, and thank you for joining us. It's been nearly 6 years since the American Invents Act came into effect and created IPRs, covered business method reviews, and post-grant reviews. And in that time frame, they've changed patent law. With the recent oil states decision, we can expect that these proceedings will continue to change U.S. patent law as we go forward here. And what was really interesting is in the last few months, we've seen a lot of major decisions that affect these AIA proceedings and are changing the landscape of AIA proceedings. So we're going to go through some of the more important changes that we've seen. We've got a lot of ground to cover here, so we'll probably be moving fairly quickly. First, we're going to address motions to amend in the AIA proceedings. Then we'll go through this no partial institution concept, and then also the scope of 315E Estoppel, the proposed rules regarding claim construction, appealability of institution decisions, conflicting court and PTAB decisions, and follow-on petitions.
It is just crazy the number of changes for one type of law.
Yeah, and I think we can expect a lot more as the PTAB is trying to figure out how best to keep everyone happy and keep our patent system helpful and strong.
Yeah.
So let's move on to talk about Aqua versus Matal, which was early October 2017 decision en banc in Federal Circuit. And this decision was very important because it effectively overturned the PTAB's earlier decision and policy as set forth in the master image decision. Aqua en banc determined that the burden of persuasion regarding the issue of patentability of amended claims is on the petitioner. Going back to the start of AIA proceedings, it was always clear that with regard to the challenge claims, the burden was on the petitioner, but there was this issue about what about amended claims, right? Because patent owners are permitted to move to amend claims, and before this Aqua decision, the patent owner had the burden of proving that the amended claims are patentable, which put a ton of pressure on patent owners and made it very difficult for patent owners to, in fact, amend the claims in AIA proceedings. So this Aqua decision, which overturned that policy, is really ground shifting. And Aqua court pointed to as justification for the decision to put the burden on the petitioner to 35 U.S.C. 316E, which specifies that in IPRs, the petitioner shall have the burden of proving a proposition of unpatentability by a preponderance of their evidence. And in 316E, there is no distinguishing between originally challenged patents and amended, originally challenged claims and amended claims. And the Federal Circuit pointed out that the PTAB had basically made its own policy divorced from statutory requirements in putting the burden on the patent owner with regard to amended claims, and so they struck that down. So in addition to putting the burden on the petitioner to show unpatentability of amended claims. The Federal Circuit also pointed out that the PTAB must consider the entirety of the record in assessing amended claims and must justify any unpatentability conclusions. And that was to address a concern that the Federal Circuit had seen and petitioners had seen where the PTAB was issuing decisions that were very conclusory regarding their unpatentability conclusions.
Oh.
So not long after, just over a month, the PTAB issued guidance on motions to amend. This is how the PTAB was to institute or implement the decision in Aqua. And the first step that the PTAB will take is to determine whether the patent owner's motion to amend complies with 316D. And basically that 316D requires that there be a reasonable number of proposed claims. Generally, that's one amended claim per original claim substitution proposal. And if the patent owner seeks to substitute more than one claim for an original claim, there's got to be some significant justification for that. So generally, go ahead.
Oh, so we're not talking about kind of the re-exam approach of submitting a ton of new claims. This is really a one in, one out. That's
correct. You can assume without some real unique justification that you, as a patent owner, are limited to one substitute claim per original claim. Also, the proposed amended claims cannot enlarge the scope of the original claims and cannot introduce new subject matter. And so if the patent owner's motion to amend complies with those requirements, the PTAB will then move to determining whether the substitute claims are unpatentable by a preponderance of the evidence based on the entirety of the record, including any opposition by the petitioner.
We have a question. What's the standard for enlarged scope going to look like for this for motions to amend?
Well, it's a really good question because the law is fairly unsettled. We were just talking about that. The law is fairly unsettled with regard to what that in fact means. We don't think that there's a per se, holding that if you were to strike out a word of the claim that would, per se enlarge the scope. It's kind of a claim, case by case analysis, and you're going to have to look at prior precedent to determine that. But in essence, you can't make the meaning of the claim any broader than it was beforehand.
All right.
So then the PTAB makes this statement, which I think is pretty important. If the entirety of the evidence of record before the board is in equipoise as to the unpatentability of one or more substitute claims, the board will grant the motion to amend. So what this means is, if you look at all the evidence and it's like, half and, it's like you're on a scale and the scale is perfectly balanced, the board is going to grant the motion and allow the amended claims. Otherwise, the board's saying that really their procedure and practice will not change. So this is the overall guidance. Just a couple months ago, the PTAB decided to designate this Western Digital decision, this is an IPR decision, as informative. And what that means is all of the PTAB panels can look to this decision for guidance. It's not precedential, meaning the panels at the PTAB are not bound to follow this decision, but it's strongly suggested that they do so. And this decision really just outlines an approach that's very similar to the guidelines that were issued in November, but provide a little more detail. So the PTAB will normally consider a proposed substitute claim only if the claim it replaces is determined to be unpatentable. So what does that mean? That means is that the normal procedure is that you're not simply adding a claim to the case. You can either cancel a claim or have this situation where you're proposing a substitute claim, and the substitute claim will only be considered if the PTAB decides that the original claim is unpatentable. So it's a conditional type of proposition.
Oh, that sounds similar to the European practice and in kind of oppositions where you get to have, they actually can have like 10 contingencies.
Okay.
But that sounds similar.
Yeah, and the difference I think would generally be that for PTAB proceedings, you're really only given one contingency, matching one substitute claim to one original claim. And the PTAB says that a patent owner should adopt a claim-by-claim approach to specifying the contingency of substitution, each, which claim for which claim and in what circumstance. So you'd want to, in your, motion as a patent owner, say, substitute claim 1 will substitute for original claim 1 on the condition that the PTAB holds that original claim 1 is unpatentable. So the petitioners, again, this Western Digital case set forth again what was held in Aqua. The petitioners have the burden of persuasion to show proposed substitute claims are unpatentable by preponderance of the evidence. And then the PTAB first must determine whether the motion to amend meets the requirements set forth in 316D and 37 CFR 42.121. So this last bullet is basically kind of restating what was said in the November guidelines provided by the PTAB. And these 316D, section 316D, and then the CFR 42.121, again, they set forth some requirements. One is that you've got basically one substitute claim per original. You're not enlarging the scope. You're not introducing new matter. And additionally, the amendment must respond to a ground of unpatentability involved in the trial. And the amended claim must be supported by the original specification or whatever specification you're relying on for priority. And I just want to point out, we've got a blog. If you go back, Gina, real quick, we've got a blog. There's a link to it at the very bottom here, and it's really a categorization of the PTAB's informative and precedential decisions. So any informative or precedential decision that's been rendered by the PTAB is on our website, categorized by topic, and we think it's very useful. So if you have any interest in that and tracking those kinds of cases, there's a link to it here.
Oh, perfect.
So since the Aqua decision, more motions to amend are being granted. Before Aqua, there was basically 5 years of IPRs, and the PTAB had granted only 14 motions to amend out of 170 decisions, and 4 of those were in full. So 4, in full granted out of 170 decisions, very rare. Works out to about an 8% grant rate for full or partial, but full would be even lower than that. Well, since Aqua, in the 8 months after the decision, the PTAB has already granted 5 motions to amend. It works out to about a 20% grant rate. So we're going to have to see how this plays out, but right now it's looking like patent owners are going to have a much better shot at amending the complaints, amended the claims after the Aqua decision.
Wow, yeah, that's a huge jump already.
So here's some takeaways regarding these motions to amend. Patent owners should consider potential claim amendments upon receiving the petition. Because motions to amend are now kind of in play, patent owners would be wise to consider the potential amendments initially upon receiving the petition, because it's going to take a long time to figure out what amendments to make, how to make them, how to preserve what you want in terms of potential infringement, and how to get around potential prior art. So these amendments also must respond to grounds of unpatentability. So you'd want the amendments to respond to each of the grounds of unpatentability alleged in the petition. And then what's interesting is the PTAB says that so long as the proposed amendments respond to grounds of unpatentability, those amendments can also address 101 and 112 issues.
Oh, wow.
So, patent owner through one of these motions to amend can actually help, try to clean up some potential issues in their claims. So this is something for petitioners to think about, because, if, for example, patent challenger deciding what to do and how to challenge these, the validity of the claims, and if you've got really strong 101, 112 grounds against the claims that are at issue, you want to think twice about filing a petition for AIA challenge because
they can now fix it.
Yeah, you might be opening the door for the patent owner to fix it. So you also need to be sure that the amendment is supported by the written description of the original specification, and you don't want to broaden the scope or add new subject matter. Also, duty of candor applies to all parties. So what that means is, as a patent owner, if you know of relevant prior art that's relevant to the newly amended claims or other prior art you found or discovered that was not part of the original prosecution, you've got to put that forward to the PTAB and argue why the amendments should be granted.
We have a question.
Yep.
So you had mentioned that the petitioner can oppose the claim amendments. Do they have to rely on the previous evidence, or can they submit new evidence?
Right. So a petitioner can submit new evidence. In fact, they can submit new prior art that this is now responding to a motion to amend. So new prior art that would respond to the amendments. In addition, the petitioner, according to the PTAB judges, including on a panel I was at a conference yesterday, stated that the petitioner can also address 112, 101 issues in their response to the motion to amend, which is interesting because, generally speaking, these at least the IPR proceedings are limited to patents and printed publications, and normally you cannot address those things as a petitioner, the 101 indefiniteness, 112 issues. So in the context of a motion to amend, those rules are kind of out the window, and you can deal with those other issues relating to validity.
Oh. This is kind of opening up with this kind of the scope, the original scope, I think, of IPRs.
Yeah. So the duty of candor applies, and that's to all parties. So one thing to keep in mind too is if you're a petitioner, so you're not you're not moving to amend any claims, you've got to, in the context of one of these AIA proceedings, if you're aware of, for example, evidence that supports non-obviousness, secondary considerations, non-obvious, like commercial success, keep in mind that you are under a duty of candor and technically would be obligated to disclose that kind of information. So just keep in mind the duty of candor applies to all parties, not just the patent owner. Also, the motions to amend are not a good idea in every situation, right? Because intervening rights apply, just like as in re-examination. So any amendment made to a claim is going to trigger intervening rights. And so you better be aware of the fact that, for example, if a patent's already expired or about to expire, it makes no sense to amend the claims because intervening rights would apply. And in certain circumstances, if you're going to have no damages after the fact, in a potential infringement case, you maybe wouldn't want to go down that road. Okay, so all or nothing. Now we're going to shift on to this no partial institutions concept. So there's a SAS institutions decision, April 24th, 2018. So the Supreme Court decided that when the Patent Office institutes an inter-party review, it must decide the patentability of all the claims the petitioner has challenged, all the claims. And so most of you probably know that before this decision, the PTAB regularly instituted only some of claims that were challenged in petitions, called partial institution. Many of the PTAB decisions on the institution were partial institutions where the PTAB only instituted the challenge on certain of the claims that were originally challenged by the petitioner. And the Supreme Court said, no, you can't do that. You've got to, instead of this partial institution, you've actually got to institute on all the claims. And the PTAB, after the Supreme Court decision, followed up and kind of went along the same lines and directed everyone to the fact that a final written decision will address all patent claims in the petition and all claims added through amendment. So the Supreme Court's decision was kind of vague. It didn't expressly address amended claims, right? So the PTAB followed up and said that decision in SAS Institute also applies to amended claims. Mm-hmm. So the PTAB's got to decide it's got to decide the patentability of all those claims.
They're going to have some overworked judges.
Yes. And so well, what about all the grounds, right? So most of you know that there can be multiple grounds of unpatentability asserted against a single claim. So a petitioner files a petition and says, claim 1 of patent X is invalid under these 3 grounds, right? That's an example of what could happen, right? One ground could be anticipated by, reference X, and the second ground could be rendered obvious by reference X plus reference Y, And so the Supreme Court decision in SAS Institute didn't address grounds. It only expressly addressed claims. So the SAS Institute decision says, okay, the board's got to institute on all the claims, but didn't say anything about, well, what if you've got multiple grounds per claim? Well, the PTAB made clear in guidance that they had provided post-SAS that there will be no partial institution of grounds, meaning that all grounds will be instituted or no grounds will be instituted. This is an all or nothing policy. So if you as a petitioner are filing a petition, going forward, either the PTAB will deny the entire petition or it will institute on the entire petition all of the grounds listed.
Which would mean their decision would say on your example of anticipation that it's not anticipated, maybe claim 1 isn't anticipated, but then it is obvious.
Right.
Okay.
And then would likely address the third as well. There's technically no requirement that the board in their decision say why they're instituting on all of the particular grounds. So it could be that you get a decision from the board that doesn't address every ground other than to say that they're instituting on all the grounds, but without kind of fleshing out the rationale and what they're thinking about each of the grounds.
Okay.
But the initial guidance that the PTAB is providing, including from the judges that are talking about the policy and answering questions, they're saying that their intention is to continue to do what they have been doing, which is to substantively address each of the grounds in a petition. So very likely, unless something changes with their policy, you would be seeing an institution decision, if they institute, addressing each and every one of the grounds and the substance of the ground to some extent. Okay, so what are the takeaways regarding SAS? Well, this all or nothing. All or nothing approach will impact the court's decision. This is district court's decisions regarding whether to stay pending AIA proceedings. So it's very common, right, for there to be parallel district court litigation involving a patent that's being challenged in an AIA proceeding. In fact, if you're looking at IPRs, a little over 80% of all IPR petitions filed were filed against patents that are currently being asserted in pending litigation. And so often the party who is challenging a patent in AIA proceedings will file a motion to stay a pending litigation while the AIA proceedings are going forward, right? And, thinking about SAS is all or nothing. And in most situations, I think a court, because one of the factors a court looks at, district court, in deciding whether to stay a case pending AIA proceedings is, will this simplify the issues for trial, right? If I grant this motion to stay and allow the PTAB to run its course and figure out whether these challenge claims are patentable, if I do that and stop this district court case, is it likely that after all that plays out, the district court case is going to be simplified, right? And given the SAS decision, I think it adds even more weight to an argument that, in fact, issues likely will be simplified, right? Because it's the SAS decision means all grounds are going to be instituted, no partial decision. So if the PTAB decides to institute, it could wipe out the entire case, right? In certain circumstances. And this is, of course, depends on the circumstances, but I think the likelihood of stays pending AIA proceedings in district court will likely increase for that reason. For example, if you've got we had an 11 patent case. If you got 11 patents and they're all unrelated, right? No parent-child deal, so they're not all rising and falling together. If you just look at the statistics, so the statistics right now are as of end of March 2018. The PTAB was instituting AIA proceedings in 67% of for 67% of the petitions.
Yeah.
And then among those that are instituted, 68% would result in a decision that's completely favorable for the petitioner. So either all claims declared unpatentable, or the patent owner files a motion for adverse judgment where the patent owner is canceling their own claims, right? So you put those two things together, that's almost 50% chance that if you file a petition, and of course, this only applies to the patents that are vulnerable, but
right.
if you file a petition on a vulnerable patent, there's basically a 50% chance you're going to see all the claims held unpatentable or canceled by the patent owner.
Yeah.
At least this is now just looking at stats. And so you can, cite those stats to the district court and think about it as your district court judge and say, look, there's a half chance of this, if you're dealing with one patent, this case goes away entirely. If you're dealing with 11 patents that are all unrelated, looks like maybe 5 or 6 are going to drop off, right? So
especially for a judge who is maybe not, super excited about having to dig into the esoteric patent litigation world.
Yeah, well, you don't want to waste your time, and no doubt about it, if you're dealing with a huge patent case and it's going to take up, a lot of your docket, you want to get that, resolve that as quickly as possible. So also, the more grounds in a petition means more grounds for potential appeal for a petitioner in the event a claim is upheld. So what this means is there's a incentive now for a petitioner to put in a lot of grounds, right? Because if the PTAB institutes, you've got all these potential grounds for appeal if you were to lose, even if we were to lose in the PTAB proceeding. Then again, there's a counter to that, and that is you shouldn't overwhelm the PTAB with numerous grounds against a particular claim. Petitioners should go only with their best grounds. So, and why is this? Well, the PTAB has said, now that we've got this SAST Institute decision where they're forced to institute on all or nothing, if you overwhelm them with the whole, laundry list of grounds against a particular claim, they will, in certain circumstances, reject your petition on that basis. They just don't have the resources to deal with your petition, and they don't want to do that, right? They want to deter petitioners from doing this and clogging the system on a single fee that they got for a single IPR petition. And so they've said that they might reject those kinds of petitions. So you've got to be very careful. You want to have as many grounds in there as possible, but at the same time, you want to focus only on the very best grounds you have and not overwhelm the PTAB.
Well, to that end, we have a question about, with this decision, is there an expectation that there would be an increase in the page length requirements for the petition?
Well, they said they're not going to do that, and I don't think so, because they are bound to get decisions done in a certain time frame, and they operate on the fees they get. And the last thing they want to do is bog down their system more. If they were to allow more pages, they might, jack up the fees for filing a petition, that kind of thing. So I don't think they're going to do anything. That's what they've said so far. So other takeaways is the patent owner might consider foregoing a preliminary response to avoid providing unnecessary preview of positions in certain circumstances. So patent owners have a right to file a preliminary response before the institution decision. Well, in view of SAS, if you're looking at a petition, you say, geez, it looks pretty good to us, there's a pretty good strong likelihood that the PTAB is going to institute on one of those grounds, or one of those grounds would support institution just based on, and you don't have a strong enough case to shoot it all down at the preliminary stage, you might not want to submit a preliminary response, because it might be all for naught, given that so long as there's only one, ground that could support the institution, the PTAB would
they're going to have to institute
on all, right? And so you might not want to give away your positions and allow the petitioner a longer time to consider them. You might want to consider filing multiple petitions per patent right up front. That means you're giving more money to the PTAB, and the PTAB would be potentially interested in entertaining those different petitions, given that you're giving them more money. And that way you're able to submit more grounds against the claims. Petitioners should consider filing petitions early enough to allow for a retry if the first petition is denied. So PTAB has a lot of discretion on what to do with what we call follow-on petitions, where the same petitioner is filing multiple petitions against the same claims at different times. And there's a whole laundry list of factors that the PTAB will consider. This might not work, the retry concept, but you should consider, if you can, as a petitioner and you're ready to go quickly, filing a petition as early as possible, and then seeing whether if the petition is denied, whether you can file a second petition and maybe get around the follow-on factors that the PTAB sometimes uses to reject follow-on petitions. Also, Estoppel will apply with respect to all grounds in a petition now, right? We've got the SAS Institute decision, which means you've got to institute on all grounds if you're going to institute. And that means that a final written decision is going to address all grounds that were in the petition. And as most of you know, there's this Estoppel concept, and once a final written decision issues in an IPR, you now have Estoppel that will prevent the petitioner from later asserting the same grounds in a separate PTO challenge or in district court. However, there's this split on what reasonably could have raised during means, and I'll get to that. So basically, the Estoppel provision that applies to final written decisions applies to all grounds that were considered during that AIA proceeding, and then any other ground the petitioner reasonably could have raised during the proceeding. So let's talk about the scope of 315E Estoppel.
The mysterious part of IPRs.
Well, it could be. Depends. Okay, so there's a little bit of background here. Estoppel in proceedings before the Patent Office is addressed in 35 U.S.C. 315E1, and Estoppel in civil actions and other proceedings is addressed in 35 U.S.C. 315E2. And this is Estoppel specifically directed to inter-party review, and I'll focus on that. There's a similar provision for post-grant review, but given the popularity of inter-party review, which is a little over 90% of all the AIA proceedings that are filed, we'll focus on these Estoppel provisions for now. But first, the 315E1 is basically saying, look, if there's a final written decision that upholds the patentability of a claim, that petitioner may not request or maintain a proceeding before the Patent Office with respect to that claim on any ground that the petitioner raised or reasonably could have raised during that review. And then Section 315E2 is basically the same concept but applied in district court to stop the petitioner from challenging in district court or ITC investigation. Okay, so there was a 2016 decision in Shaw versus Automated Creel, and that was a holding that Estoppel under Section 315E does not apply to grounds in an IPR petition that were not instituted by the PTAB. So if you're a petitioner, you file a petition, and there was a partial institution where the PTAB says we're going to institute IPR review on, grounds 1 and 2, but not grounds 3, 4, 5. Well, the Shaw decision was meant to say that Estoppel would not apply in that case on grounds 3, 4, 5. So because the PTAB rejected grounds 3, 4, 5 in this example, there can be a no Estoppel because the Federal Circuit pointed to language in Section 315E, 35 U.S.C. 315E, which says that Estoppel applies for any ground that was raised or reasonably could have been raised during the IPR review. And if the PTAB had rejected grounds, there was no opportunity for the petitioner to raise those grounds during the IPR because they were rejected in the first place, right, before the IPR even got started. And there was also this HP decision that was along the same lines that I've cited here. And so what's interesting, though, is Shaw was an important decision that petitioners would point to say, hey, look, we shouldn't be stopped from raising grounds in a district court case, pending district court case, that were not instituted by the PTAB, and they would point to Shaw, right? Well, Shaw is going to be moot going forward, at least if this Shaw decision, if its holding is limited to instances where the PTAB has denied grounds, it's going to be moot for all post-SAS final written decisions, because all post-SAS final written decisions will be all or nothing, right? Yeah. So there'd be nothing to complain about here. But if we go to the next slide, there's a split in the district court decisions as to, the scope of 315E estoppel. And some courts say that Shaw's holding is not limited to situations where the PTAB has a partial rejection, where the PTAB rejects only certain grounds, but rather the rationale in Shaw applies to any situation or any ground that was in fact not considered during inter partes review. So what that means is, with these courts, they're saying that, look, even if a petitioner decides not to include certain grounds in its petition, a petitioner might know of certain prior art, it might know of certain arguments that he or she could make in the petition, but decides just not to include those in the petition. These courts say that the Shaw rationale indicates that estoppel should not apply to those withheld grounds either, because if you look at the rationale in Shaw pointed to the phrase "during the inter partes review." So estoppel only applies to grounds during the inter partes review, and if you never put the grounds into your petition, the grounds will never make it into the inter partes review, and therefore there should be no estoppel on grounds that are not part of the petition.
So these cases, this line would be, kind of lead people to maybe holding back some art.
That's right.
Yeah.
Yep. To get kind of a second bite of the apple with a different PTO proceeding or in district court. And so you can see there's a recent decision in this I can't pronounce it, the K party District of Massachusetts 2018 case that explains that rationale. And then there were prior decisions in different courts. I just highlighted one from Northern District of California and one from the District of Delaware. But other courts have concluded that estoppel would apply to grounds that a petitioner reasonably could have but chose not to include in the petition, right? And these courts say, look, this doesn't make sense. The whole concept of this estoppel was to limit petitioners to, if you're going to choose to use one of the AIA proceedings, you're stuck with the AIA proceeding, and you can't, hold back and, use gamesmanship to take, multiple bites at the apple, which would get away from the whole purpose of the AIA proceeding, which is to make things efficient and minimize litigation costs, et cetera. So these courts, go the opposite direction. So right now there's this split of opinion in district court. Also, you should note that the PTAB recently addressed this issue, and the PTAB comes down on the side of the courts that say that there should be estoppel on grounds that a petitioner could have put into the petition. And they made this decision in Aqua. So takeaways regarding the 315E estoppel. Well, the scope of the estoppel will depend on district court. If you're in the Northern District of California, Delaware, or District of Massachusetts, for example, it could be that you are going to be able to assert grounds in the district court case after a negative final written decision in an AIA proceeding on grounds that you could have put in the petition, the AIA proceeding petition. Other courts not, you won't be able to do that. So the Federal Circuit is going to need to resolve this split at some point. And until the split is resolved, you might want to consider, even if you're in one of these jurisdictions that might allow you to, get the second bite of the apple, you might want to consider the fact that the Federal Circuit could at any time reverse, decide this issue, right?
Yeah.
Or the district court, depending on the judge, might decide, to go a different way, and you want to make sure you're being safe, so you want to include the grounds you can include in your petition to be safe.
So for, accused infringers having any backup positions, the best then would be for something that relies on something that couldn't have been brought. So, whether it's a first sale or a prior disclosure that's not a printed publication, such as a product, maybe doing some research on that to have at least some backup position that's not just a could have been brought.
That's right. PTO. That's correct. Good point. Okay, we'll move on to claim construction. So the PTAB has proposed rules regarding claim construction. The PTAB has proposed changing the claim construction standard for AIA proceedings from what is currently used, which is the broadest reasonable interpretation, which is the same standard used in reexaminations and original prosecutions, changing it from that to the same standard applied in federal courts and ITC proceedings, which is the Phillips standard, right? The ordinary person of ordinary skill in the art standard, right? Looking at it from that perspective.
It's interesting. The PTAB is making it easier to amend claims and then changing the standard.
Right. Which a little bit, not diametrically opposed, but the rationales there are, I guess, in somewhat conflict. But so, it's interesting to me, I think, and we'll talk about the takeaways. I personally don't have strong views either way. I do see why the PTAB is doing this, and I do think that they're doing it to try to bring those stats down, right? Change it from where it's basically 50% chance of invalidating everything down a little bit to something that is going to make everyone happy about, our patent system and the strength of our patents. And they're also proposing adding a rule that the PTO will consider any prior claim construction determination concerning the claimant issue made in a civil action or ITC proceeding that's timely made of record in the AIA proceeding. So basically they're saying, look, if the district court's ruled on claim construction on this particular claim that's being challenged, we're going to give that, serious consideration. So again, it's going back to this, I think, trying to put the PTAB proceeding results somewhat in line with the kind of results you get for invalidity challenge in district court.
Okay.
Right? And the PTAB issued this notice of proposed rulemaking on May 9th, and comments are due July 9th. The PTAB has been, shouting this from the rooftops for people to provide comments by July 9th. You can do that on the website very easily. And I think your comment will even be reflected on the website, so for other people to see. Anyone can make comments about whether you think this, rule change is good or not. But you got to do it by July 9th, so pretty quickly. And what justification has the PTAB provided for wanting to change the claim construction standard? Well, they've said that changing the claim construction standard to Phillips would provide greater uniformity, predictability, and judicial efficiency. So the takeaways are parties should presume that the PTAB will likely adopt prior federal court or ITC claim construction rulings addressing challenge claims, and so really consider those prior determinations before deciding whether to file an AIA proceeding and how to respond to a petition. Also be careful what you say about the claims in litigation. The PTAB will likely give significant consideration to positions taken by the petitioner or the patent owner in litigation, even if there isn't a final claim construction ruling in the district court case. Prospective petitioners should carefully consider any applicable prior claim construction rulings in determining whether to file the AIA petition, and district courts will likely give great weight to PTAB claim construction using the same standard. So we've already seen district courts, now looking at it from the other perspective, district courts will often look at what the PTAB has done in terms of construing the claim. And I think, if the standards are in line, they're both using the same claim construction standard, we'll probably see more likely that district courts will give weight to PTAB decisions going forward on claim construction.
So as a petitioner putting together your petition, if those claims have already been construed in multiple litigations, does it make sense then to just kind of assume that'll be the adoption and outline your petition accordingly?
Well, it depends, right? You'd always want to qualify and not assume. You've got to have, I think, come at it from a perspective that the PTAB will likely give a lot of weight to those claim constructions and might adopt them wholesale. But at the same time, you want to argue if you don't like the claim construction, why you think it's wrong, and if there is in fact a reasonable argument for why it's wrong, of course, point that out. But I think you need to assume that those claim constructions are going to come in, particularly if they're not favorable for you, because the other party will bring them in and raise them in a timely fashion. So you've got to kind of consider them and at least have an argument prepared for either why that prior claim construction should be adopted in your AIA proceedings, or why, even though the district court held in this prior decision, that the claims mean X, that they got it wrong, right? Yeah.
Okay, yeah, that makes sense.
So let's move on to the appealability of institution decisions. So this is for IPRs. Section 314D says no appeal. That's the title. The determination by the director whether to institute an IPR under this section shall be final and non-appealable. And it's clear that this section applies to determinations by the PTAB as to whether a petitioner has shown a reasonable likelihood of success, right, that they're going to prevail as to at least one challenge claim, right? So the standard for deciding whether to institute, this is the PTAB standard, and IPR is whether the petitioner has shown a reasonable likelihood of success that it will prevail as to at least one claim, right? And if the PTAB makes a determination on that standard, the petitioner has no grounds to appeal that decision. Neither does the patent owner, according to 314D. But then there's this question about what about other grounds for denying an institution, right, decision, or granting institutions. For example, if you go to the next slide, the PTAB had relied on Section 312A3 to deny petitions in the past, right? And that section requires that a petition identify with particularity each claim challenged, the grounds on which the challenge to each claim is based, and the evidence that supports the grounds for the challenge to each claim. So this is a procedural, technical requirement in how you're laying out your petition, and you've got to link everything up and, show what evidence you have that supports each ground, and you've got to link it up in a way that makes it understandable to the Patent Office. And if you don't do that, the PTAB had been known to deny a petition, saying, look, we can't follow your petition. Yeah. You might have great arguments in there, we just can't figure it out, so we're going to deny your petition under 312A3. So there was a question about, well, what about that? Is that appealable, that determination on institution? And in the Cuozzo decision in 2016, Supreme Court concluded that, yes, the Section 314D bars appeals of determinations under this Section 312, right, A3, which is a kind of technical procedural type requirement. The court concluded that that provision barring appeal of institution decision, 314D, must at the least forbid an appeal that attacks a determination whether to institute review by raising this kind of legal question and a little more. And the legal question they're referring to is the legal question of whether a petition satisfies 312 and putting, linking everything up. But the Supreme Court did say that certain kinds or aspects of institution decisions may be appealable, but they didn't specify which ones. So although Section 314D says no appeal, right, on an institution decision, the Supreme Court saying, well, there could be some kinds of decisions that
could be appealable.
It could be appealable that are institution decisions. So if we go to the next slide, there's this recent Wi-Fi 1 decision, 2018 case, that's really important, and because this issue comes up a lot. This is an en banc decision, and the Federal Circuit held that time bar determinations under Section 315B, which is the time bar, the one-year time bar for inter-party reviews, those determinations are appealable, right? And this en banc decision overruled a contrary conclusion reached earlier by the Federal Circuit in this Cates decision. And the rationale for this Wi-Fi 1 en banc holding is that to overcome a strong presumption in favor of judicial review of agency decisions, Congress must clearly and convincingly indicate an intent to prohibit review. So there's this general strong presumption in favor of judicial reviews of agency actions, and of course the PTAB is an agency, PTO is an agency. And so there's a strong presumption in favor of a judicial review of PTO or PTAB actions. And in order to overcome that strong presumption, the Congress must clearly and convincingly indicate in statute their intent to prohibit that kind of review. And Wi-Fi 1 looked at the statute and found no clear convincing indication of intent to bar appeal of time bar determinations. Yeah. So they looked at section 315B, 314, which was on the slide. We had a couple slides earlier. And they said, look, looking at that provision, it doesn't indicate to us some strong indication of intent by Congress to prohibit the appeal of these time bar determinations, which are not substantive determinations, have nothing to do with whether the petitioner has satisfied that standard of showing a reasonable likelihood of success on the substance. This is a procedural determination, and because it's procedural, there was no convincing indication of intent in 314D to limit those appeal of these decisions.
Well, and most of these time bar questions are usually kind of tied to the real party and interest.
That's correct. That's correct. Often they are.
So.
Yep. So just to go into what happened in the Wi-Fi case, it went back down to the district court to determine the substance of the time bar determination, and then went back up to the Federal Circuit, and then the Federal Circuit affirmed the PTAB's decision of no time bar 2-1. And so in this case, Wi-Fi, the patent owner, had argued that Broadcom was in privity with defendants to a previous litigation involving the patent that was filed over a year before Broadcom's IPR, and this is what Gina was just referring to, this kind of scenario. And the PTAB denied a motion that Broadcom had made seeking discovery regarding indemnity agreements, defense agreements, payments, email, and other communications between Broadcom and the defendants. Broadcom obviously was seeking that discovery in an effort to establish privity and support the time bar, the time bar defense to IPR, and it's really something that will come up in all these, as Gina mentioned. Most of these time bar decisions are instances where the petitioner is filing a petition and a party that's kind of closely related to the petitioner was already sued for infringement on the patent that they're seeking to challenge over a year before the petition is filed, and then the patent owner seeks to establish that this relationship between the petitioner and the parties to that prior litigation is so strong and close that there's what's called privity or real party and interest situation. And in order to establish privity or real party and interest, the patent owner obviously, in many instances, must get discovery to show that how close this relationship is. And so that's what Broadcom tried to do. And I think Broadcom here was seeking too much, right? And so often the PTAB will say, look, this is a fishing expedition. This is not, these AIA proceedings are not district court litigation where full-blown discovery can take place. It's limited discovery, and then you've got to be very specific in what you need. Here it looked like Broadcom maybe requested too much, and the PTAB denied the motion for discovery. And then the PTAB held that because there was no showing of privity, there was no time bar. Okay, and then this last bullet's kind of interesting, just saying the PTAB says that other than Wi-Fi's conjecture, there's no evidentiary support for Wi-Fi's theory that Broadcom was acting at the behest or on behalf of the defendant companies when it challenged the patents. So
you can't seek evidence and then your evidence is weak.
It's kind of a strange, yes, exactly. So good luck, right? If you're going to try to establish privity or real parties and interest relationship in order to support time bar determinations, it's not a straightforward thing, right? That's one takeaway. It's very difficult to do that. And if you're a patent owner and you're trying to establish a time bar based on privity or real party and interest, you need to seek discovery promptly. And, as this case indicates, it's quite possible that PTAB is going to deny your request for discovery. So what you want to do is make sure your discovery requests are very targeted, right? The PTAB has shown that they are willing to grant motions for additional discovery if your motion for the discovery is very targeted to particular information and you have a reason that you can demonstrate to the PTAB to believe that that specific targeted information you're seeking would have what you think it will have. It'll show what you think it will show. You've got to actually have some of your own evidentiary support that you already know about to kind of support that position that you think that targeted discovery would show what shows. So what I also recommend is if there's this parallel litigation and before there is a petition filed challenging the patents that are at issue in the litigation, that if you're a plaintiff, you should consider seeking discovery in the district court that would support your privity RPI position, although district courts have been known to deny that kind of discovery as well because it's not directly related to what's going on in the district court.
But you might have a little bit easier time.
Okay, so then we've got conflicting court and PTAB decisions. We've got to move real quickly, so we're just going to go real quick. Novartis case basically says that even if there's a decision in federal court that upholds the validity of a patent, that decision is not binding on the PTAB, and the PTAB can subsequently hold that that same claim that was upheld by the federal district court is unpatentable, and even based on the very same grounds.
Wow.
So you can read more about it on this slide. Basically, the takeaways are patent challengers should not give up on AIA proceedings, even when a federal court has determined that the challenge claims are invalid or over essentially the same arguments raised in the AIA proceedings. And timing is important because of how these things play out. All right, and follow-on petitions, that's our last topic. There's a General Plastic versus Canon decision, September 9th, 2017, indicating that PTAB has broad discretion to deny follow-on petitions under 35 U.S.C. 314A and 37 CFR 42.108A. And so a follow-on petition is where one petitioner files a petition against a particular patent and then later files a second petition against that very same patent, right? And there's a whole list of factors that the PTAB will consider in determining whether to grant or deny that second follow-on petition, and they're outlined in this General Plastic versus Canon case. I won't go through all of them, but you can find the factors here on this slide, and if you want to see the decision, you can go to that our patentdevelopments.com website that was on an earlier slide where we categorize all the decisions, and the General Plastic decision's in there as well. So the rationale for, if you go to this last slide real quick, in the General Plastic case, the PTAB denied institution of a follow-on petition. The reason they did that is that the follow-on petition addressed the same claims as in the first petition. The petitioner provided no explanation why it could not have found the new prior art that was, in the second petitions before filing the first petitions through reasonable diligence. The petitioner filed the follow-on petitions after it had the opportunity to consider preliminary response by the patent owner, decision denying the institution, and decision denying rehearing. And so basically the PTAB thought that this was a strategy by the petitioner to consider what the PTAB and the patent owner were saying about the claims, and then strategically using that and holding in their back pocket these new, better challenges, and then using those in a follow-on petition. And they don't want gamesmanship like that. So the petitioner also provided no meaningful explanation for why it took 9 months to file the follow-on petition. So anyway, those are factors to consider. We've got more information about this case and follow-on petitions on that website.
And so, we've been answering questions, but feel free to type in any additional ones. We had a question regarding the new proposed claim construction standard and whether you think there's going to be a risk that there'd be a legislative response, from changing the BRI to the Phillips standard.
I don't think that that is a major concern, and number one, because I think people, for the most part, realize that although the PTAB proceedings, the AIA proceedings are very effective, that there are some negative repercussions of that, and patent owners are upset about the fact that they can spend so much money getting a patent portfolio together and then focus on a very small subset to enforce, and then even once you focus on those strong patents, that you've got to then be on the defensive and spend a lot more money defending the validity of those patents before you have an opportunity to even go forward with your enforcement case. And so I think there would be a strong argument for why this makes sense, and I think overall, I think it's overall a good thing, and I have a hard time believing that there would be enough pushback from constituents and even special interest groups would be strong enough to kind of overcome this. Yeah. What could be, I think, a good rule, but not a drastic difference.
Yeah, that makes sense. Thank you, everyone, and feel free to reach out to either Clint or myself if you have any follow-on questions. You'll be receiving a thank you note after this that'll include the slides and a link to the recording and replay of the presentation.
Thank you, everyone.